5 seconds. Start. The present appeal is directed against the judgment and order passed by the learned session judge, whereby the appellant herein was convicted for the offences punishable under section 302 and section 307 of the Indian Penal Code, full stop. The prosecution case, in brief, is that on the day of the incident, a heated argument took place between the accused and the deceased over a property dispute, full stop. It is alleged that the accused, in a fit of rage, took out a sharp-edged weapon and inflicted several blows on the vital parts of the body of the deceased, full stop. The incident was witnessed by the complainant, who is the brother of the deceased, full stop. When the complainant tried to intervene and save his brother, the accused also attacked him with the intention to kill, causing grievous injuries, full stop. The learned counsel appearing for the appellant has vehemently argued that the entire case of the prosecution is based on interested witness and there is no independent corroboration, full stop. It is submitted that the medical evidence does not support the ocular testimony provided by the eyewitness, full stop. Furthermore, it is contended that there was a significant delay in lodging the first information report, which has not been explained by the prosecution, full stop. The defense further argued that the weapon of offense was recovered from an open place assembled to everyone and therefore, the recovery cannot be relied upon under section 27 of the Evidence Act, full stop. On the other hand, the learned public prosecutor submitted that the evidence of the injured witness stands on a higher footing and cannot be discarded merely because he is a related and a relative of the deceased, full stop. We have carefully considered the rival submissions and pursued the record, full stop. In a criminal trial, the testimony of an injured witness carries great weight, full stop, unless there are compelling reasons to believe that the witness is lying, his presence at the spot cannot be doubted, full stop. In the present case, the injuries sustained by the complainant are well documented by the medical officer, full stop. The minor contradictions in the statements of the witnesses, as pointed out by the defense, are not sufficient to shake the core of the prosecution story, full stop. It is a settled principle of law that the court must separate the grain from the chaff, full stop. The evidence must be appreciated as a whole to see whether it inspires confidence, full stop. The contention regarding the delay in FIR also does not hold much water in the fact of this case, full stop. It is natural for the family members to first provide medical aid to the victim rather than rushing to the police station, full stop. The primary concern in such situations is to save a human life, full stop. Therefore, comma, the delay, comma, if any, comma, is reasonable and does not suggest that the FIR was an afterthought or a result of consultations, full stop. As far as the recovery of the weapon is concerned, comma, the Panch witness have clearly supported the prosecution's various and version regarding the discovery made at the intents of the accused, full stop. The forensic report further confirms the presence of human blood on the weapon, comma, which matches the blood group of the deceased, full stop. Turning to the question of sentence, comma, the learned counsel for the appellant requested for a lenient few, comma, stating that the accused is a first time offender and has a family to support, full stop. However, comma, considering the brutal nature of the crime and the cold-blooded manner in which the offense was committed, comma, we find no reason to interfere with the sentence of life imprisonment awarded by the trial court. The act of the accused has not only deprived a family of its breadwinner but has also created a sense of insecurity in the locality. Full stop. The balance sheet of aggravating and mitigating circumstances clearly weighs in favor of the prosecution.